Another important topic to think about are powers of attorneys. I think everyone should have powers of attorneys, no matter how young or old they are, or no matter what their status is in life. Powers of attorneys, there are two different types of powers of attorneys, and they're effective while you're alive. But if you become disabled or incapacitated, either mentally or physically, and you cannot make decisions for yourself, it's important to have powers of attorneys in place so that someone else has the legal authority to make those decisions for you. The first type of power of attorney is generally called a durable power of attorney for finances, or a financial power of attorney. Those are some of the terms. Those take effect, again, once you've become disabled or incapacitated, and allows an agent to take over on all of your daily affairs for you. So they can do your banking, they can monitor your investments, they can sign your tax returns, they can deal with Social Security and the government. And so those are some of the things they can do on a financial basis for you if you're incapacitated. Now, even spouses need these. A lot of times I have married couples say to me, well, my spouse and I are joint on all of our accounts anyway, I don't need that. But think about it. If you have a 401k or a 453b or some kind of deferred comp or life insurance, only your name is on those accounts. Your spouse is just your beneficiary. So if you become disabled or incapacitated, you won't be able to access those accounts, and neither will your spouse, because they are just a beneficiary. That means that they're not entitled to that money or control of that money until you pass away. But with the power of attorney, your spouse would then be able to access those funds if they needed it for health expenses, or they could direct the monitoring of those funds, the investments of those funds, without having to go to court to be appointed as your conservator. That's what powers of attorneys do. If a spouse had to go to court or another family member, then you're talking about a longer process and a very expensive process. Powers of attorneys are very inexpensive and very easy to obtain. The other type of power of attorney is a health care power of attorney, or some people call it a medical power of attorney. That's another very important document. In that document, you appoint a patient advocate to make your medical decisions for you. And that's also the document where you put your preferences on life support. So if you do not want to be on life support, if you're in some kind of irreversible coma or persistent vegetative state, then it's important that you have a properly executed healthcare power of attorney so that you can be taken off of life support in one of those instances. Another thing about healthcare powers of attorneys is they should have a HIPAA waiver in them. And what I mean by that is the privacy law, the HIPAA privacy law came out a few years ago, where it really restricts individuals' access over your medical records. But with a healthcare power of attorney that has the HIPAA language in it, then you're saying, it's okay, I understand these privacy laws, and I still want my patient advocate to make my medical decisions and be able to have access to my medical records. That's very important. If you have a healthcare power of attorney already that does not contain this HIPAA language, you really need to have that updated and have an amendment done to that in order to prevent any possible problems with your patient advocate using your healthcare power of attorney in the future. So there are two different types of powers of attorneys. One's for finances, one's for healthcare. They're both very important documents. I think everyone should have those. They're easy to get and they're not expensive. So those are things that you should also consider when you're considering getting your estate planning done. Thank you.